Welcome to Chapter 11 and buckle up because today we begin the most dramatic storyline in all of data protection law international transfers. This is the domain where court rulings have demolished entire legal frameworks overnight and where one determined law student changed how the whole world moves data. Here's our route. First, the foundations. Why does the GDPR restrict data leaving the European Economic Area at all, and what exactly counts as a transfer? Spoiler, the data doesn't need to move, someone abroad merely needs access. Then, the risks the law is guarding against foreign surveillance regimes, missing remedies, and the EDPB's guidance on spotting transfers hiding in plain sight. From there, the golden ticket adequacy decisions under Article 45. How the Commission assesses a country who's currently on the list and why adequacy can be granted, reviewed, and withdrawn. And finally, the saga itself. Safe Harbor and its destruction in Schrems I, Privacy Shield and its destruction in Schrems II, and the current chapter, the EU-US Data Privacy Framework, along with the open question of whether history repeats a third time. Why does this matter so much? Because in a cloud-powered world, almost every organization transfers data, whether it knows it or not. Let's make sure you know it. Let's start with the fundamental question. Why does European law care where data goes? The answer sits in one elegant idea. Protection must travel with the data. Think about what would happen without transfer rules. A company could collect data in Paris under full GDPR protection, then ship it to a server in a country with no privacy law whatsoever, and poof, every right we've studied evaporates. Access requests, meaningless. Security obligations, gone. The GDPR would be a fence with an open gate. Chapter 5 of the regulation, Articles 44 through 50, closes that gate. Article 44 states the principle. Any transfer to a third country may take place only if the chapter's conditions are met and, crucially, the level of protection guaranteed by the GDPR must not be undermined. Now, what counts as a transfer? Here's where intuition fails people. It's not just shipping a database abroad. The EDPB describes it through cumulative criteria. Essentially, a controller or processor subject to the GDPR discloses or makes personal data available to another organization in a third country. And making available includes remote access. Let me repeat that because it's the trap from Chapter 6. If your support team in another country can view EU customer records on their screens, that viewing is a transfer, even though the data never left your European server. The chapter then offers a hierarchy of solutions, and hold this structure, it organizes everything ahead. First choice, adequacy. The destination country is officially safe. Second, appropriate safeguards. You build the protection contractually or structurally. Third, derogations. Narrow exceptions for specific situations. Adequacy, safeguards, derogations in that order. We'll climb this ladder across 2 chapters. So what exactly are we afraid of when data lands in the wrong jurisdiction? Let's name the risks concretely, because they're the reason this entire legal edifice exists. Risk number 1. Government access without limits. In the EU, state access to personal data is constrained by necessity, proportionality, and judicial oversight. Many third countries operate differently. Intelligence agencies may access data in bulk, without warrants, without notifying anyone, ever. Your customers' data, transferred for innocent business reasons, becomes raw material for foreign surveillance. This isn't hypothetical. It's precisely what the Snowden revelations documented, and precisely what triggered the Schrems litigation we'll cover shortly. Risk number 2. No remedies. Suppose a person's data is misused abroad. Where do they complain? In the EU, there's a supervisory authority, courts, compensation rights. In a country without data protection law, the individual faces a locked door in a language they don't speak. Rights without remedies are decorations. Risk number 3, the onward journey. Data rarely stays put. Your recipient in country A backs up to country B, whose support sits in country C. Each hop multiplies exposure, which is why transfer thinking must cover the entire chain, not just the first destination. The EDPB's guidance sharpens your vision here. Its three cumulative criteria for identifying a transfer help you spot the hidden ones: the remote administrator, the offshore analytics tool, the global help desk. And its consistent messages map your flows end to end. When I run transfer assessments, the first workshop is always cartography. Where does data actually go? Who can actually see it? Organizations are routinely astonished by their own maps. Draw yours before anything else, because you cannot protect a journey you haven't traced. Now for the golden ticket of international transfers, the adequacy decision. When the European Commission formally decides that a third country ensures an adequate level of protection, something wonderful happens. Data flows to that country as freely as to another EU member state. No contracts, no special authorization, no extra paperwork. Adequacy is the closest thing this field has to a magic word. But what earns it? Here's the standard, refined by the Court of Justice in Schrems I. The country must offer protection essentially equivalent to the EU's. Not identical, laws can differ in structure and style, but equivalent in outcome. The Commission's assessment under Article 45 examines the whole legal ecosystem: the rule of law and respect for human rights, relevant legislation including, pay attention, rules on government access to data for national security and law enforcement, the existence and effective functioning of an independent supervisory authority, enforceable individual rights and effective administrative and judicial redress, and the country's international commitments like membership of Convention 108. Notice what that list really tests. Not just whether the country has a privacy statute, but whether the statute means something in practice. A beautiful law with no independent regulator, or with a surveillance regime that overrides it, fails the essential equivalence test. That's exactly the reasoning that would later demolish two US frameworks. Adequacy can also be granted with precision to a whole country, a territory, a specific sector, or an international organization. Canada's adequacy, for instance, covers only its commercial sector under its private sector privacy law. And adequacy is never a diploma hung permanently on the wall. It's a living judgment, reviewed at least every 4 years, monitored continuously, and revocable if the country's protections erode. Which brings us to who's actually on the list. Let's tour the adequacy map as it stands, and more importantly, learn to read its politics, because every entry tells a story. The list includes Andorra, Argentina, Canada for its commercial sector, the Faroe Islands, Guernsey, Israel, the Isle of Man, Japan, Jersey, New Zealand, South Korea, Switzerland, the United Kingdom, Uruguay, and the United States. But for the US, only companies certified under the Data Privacy Framework. A modest list, isn't it? Out of merely 200 countries, barely a dozen make the cut, which tells you how demanding essential equivalence really is. Now the stories inside the list. Japan's adequacy came with homework, supplementary rules that Japanese companies must apply specifically to data received from the EU, tightening protections beyond their domestic baseline. Adequacy as negotiation, the EU exporting its standards. The United Kingdom is the most fascinating case study. Post-Brexit, the UK kept a carbon copy of the GDPR, so adequacy seemed natural. But the EU attached something unprecedented, a sunset clause. UK adequacy expires automatically after a set period, unless actively renewed, and the Commission watches UK reform proposals closely. The message is unmistakable. Drift too far from European standards, and the bridge comes down. For UK businesses, adequacy is a privilege under continuous review, not a birthright. And the US entry, the DPF, carries an asterisk written in litigation history, as our next 3 slides will show. The professional habit this slide teaches: verify currency. Adequacy lists evolve, decisions get challenged, sunset clauses tick. Before relying on adequacy in real work, check the Commission's current list. Today's answer, not last year's. In an exam scenario, If a company assumes a country is adequate forever without checking, that assumption is the planted flaw. Now the saga begins. Let me tell you the story of how one Austrian law student toppled a transatlantic data framework because it's the best story in privacy law and it's all exam relevant. First, the setting. The US has no comprehensive federal privacy law, so it could never qualify for ordinary adequacy. Yet EU-US data flows were commercially enormous. The solution, invented in 2000, was Safe Harbor, a clever workaround. American companies would voluntarily self-certify to a set of privacy principles, and the Commission declared that certified companies provided adequate protection. Thousands of companies joined. For 15 years, data flowed. Enter Max Schrems, then a law student who had studied in California and noticed how casually American tech treated European privacy law. In 2013, Edward Snowden's revelations landed, documenting mass US surveillance programs with direct access to data held by major American companies. Schrems connected the dots and filed a complaint with the Irish regulator since the relevant company's EU headquarters sat in Dublin. His argument was elegant. My data, transferred under Safe Harbor, ends up available to US intelligence without meaningful limits or remedies. How is that adequate protection? The case climbed to the Court of Justice, and in October 2015, the court agreed, invalidating Safe Harbor entirely. The reasoning matters for your exam. Adequacy demands protection essentially equivalent to EU standards. Legislation permitting generalized access to communications content compromises the essence of private life, and the absence of effective remedies compromises the essence of judicial protection. Safe Harbor's principles bound companies, but yielded entirely to US national security demands, so the scheme failed. One more holding with lasting force. A commission adequacy decision cannot prevent national supervisory authorities from examining complaints about transfers. Regulators keep their own eyes. Overnight, thousands of companies lost their legal basis for transatlantic transfers. The scramble that followed produced a successor, and history prepared to repeat itself. After Safe Harbor's collapse, negotiators on both sides of the Atlantic rushed to build a sturdier bridge. In 2016, they unveiled Privacy Shield, and on paper, it was a genuine upgrade. Stronger privacy principles, active oversight by the US Department of Commerce, annual joint reviews, written assurances about surveillance limits, and a new invention, an ombudsperson in the State Department to handle European complaints about intelligence access. Over 5,000 companies certified. Surely this would hold? Max Schrems didn't think so. His original complaint, reformulated, kept moving through the system, now also targeting the standard contractual clauses that companies used alongside Privacy Shield. In July 2020, the Court of Justice delivered Schrems II, and the verdict was thunder. Privacy Shield invalidated. The court found US surveillance law still failed proportionality. Programs authorizing bulk collection weren't limited to what is strictly necessary, and the ombudsperson, however well-intentioned, was neither sufficiently independent from the executive nor empowered to bind the intelligence agencies. Not a court, not equivalent, not adequate. But here's the twist that defines compliance work to this day. The SEC survived with a condition that changed everything. Contracts, the court reasoned, bind only the companies signing them. Foreign governments aren't parties. So exporters relying on SCCs must verify case by case whether the destination country's law allows the clauses to be honored in practice, and where it doesn't, must add supplementary measures or not transfer at all. Feel the shift in that sentence. Before Schrems II, transfers were paperwork. Sign the clauses, done. After, transfers became analysis. Study the destination's surveillance law. Assess, supplement, document. An entire discipline, the transfer impact assessment, was born from this single judgment, and it's waiting for us in the next chapter. So, where does the transatlantic story stand now? Welcome to attempt number 3, the EU-US Data Privacy Framework, adopted as an adequacy decision in July 2023. Let's see what changed and what questions remain. The foundation this time is a US presidential executive order on signals intelligence, and it directly addresses the two wounds Schrems II identified. First, proportionality. The order commits US intelligence to collecting data only when necessary and proportionate to defined objectives, importing, notice, the exact vocabulary of European law. Second, redress. In place of the underpowered ombudsperson stands a two-tier system. Complaints go first to a civil liberties officer within the intelligence community, then, on appeal, to a newly created Data Protection Review Court, staffed by judges with protections for independence, empowered to issue binding remedial decisions, including deletion of data. Mechanically, the framework works like its predecessors. US companies self-certify to the framework principles under Department of Commerce oversight, and only certified companies enjoy the adequacy coverage, which means your compliance check is concrete. Before treating a US vendor as adequate, verify their active certification on the official DPF list. Transfers to non-certified American companies still require SCCs or another Article 46 safeguard, with all the assessment duties attached. Now the open question everyone asks me, will this framework survive where two died? Privacy advocates, Schrems among them, argue an executive order is not legislation. A future administration could amend it, and debates continue over whether the review court's guarantees satisfy the EU treaty standard for a tribunal. Challenges are expected to reach the Court of Justice eventually, and the privacy world half-jokingly awaits Schrems III. Your professional posture? Use the framework. It's valid law today, but architect for resilience. Wise organizations keep SCCs ready as fallback because this saga has taught everyone the cost of single points of failure. History may not repeat, but it rhymes, and we plan for rhymes. What a chapter! You've just absorbed the full transatlantic saga, why transfers are restricted, what adequacy demands, and how Safe Harbor and Privacy Shield rose and fell before the current data privacy framework took the stage. Very few candidates walk into the exam with this story properly organized in their heads, and now you're one of them. Quick pit stop before the sequel. If this series is powering your preparation, subscribe to the channel. One click unlocks this playlist plus all our other certification playlists, and it keeps free training like this flowing to the community. And definitely stay in sequence, because next chapter is the practical half of the transfer story. Adequacy covers a dozen countries, but what about the other 180? That's where standard contractual clauses, binding corporate rules, derogations, and the transfer impact assessments born from Schrems II come in. Today was the drama, next is the toolkit. For the complete preparation experience, our full CIPP/E course on Udemy adds the assessment layer, chapter quizzes, full-length practice tests modeled on the real exam, role-play scenarios like advising a company the morning after an adequacy decision falls, and downloadable revision toolkits. You'll find the link in the description below. Take a break, and here's your self-test on the way. Explain to an imaginary colleague why the ombudsperson failed but the Data Protection Review Court might not. Then meet me in Chapter 12. The toolkit awaits.